I feel a bit unfair to ask this question with only a minute and 50 seconds left. Back to 249 and to section 5A, where we've got this statement that any bodies concerned may make an amended decision correcting any error of law or fact contained in that decision. So any error of law, to me, I read that as being just without limits of what you can do. Whereas we know we've got section 146A where you can correct clerical errors. It's kind of defined there. Could you suggest what would be defined by any error of law? It's limitless, isn't it?
Well, the language is limitless. So essentially what you get when the board makes a decision is a draft decision or not a final decision. And it's open to being amended unilaterally by the board within 8 weeks.
Only by judicial review.
But if there's a judicial review at any time. So two things I think will happen. So within the 8 weeks, so the applicant will contact the board to point out errors in the decision and will be asking the board to amend its decision. It's unfair to the public who have the 8 weeks to prepare for judicial review. So they don't know whether the decision is actually final or not. So in a piece of legislation that's meant to increase legal certainty, it kind of sticks out a bit as inconsistent. The problem is it's a kind of, I heard what the department said about it. So firstly, they said it was a minor amendments, which isn't reflected in the bill. And there's already section 146A which deals with that, which is in a different part, which is in the administrative part. So it's definitely there to deal with judicial review. The problem is that the decision is the written decision. So it doesn't matter what they thought they were deciding. Just as like a legislature, it doesn't matter what you thought you were enacting. It's the words on the page that are the decision. And this idea that you can, well, we actually did take it into account, we just forgot to write it down, and we'll just go back and fix that, is completely contrary to any kind of concept of good administration. Like if the board needs 8 weeks to check its decision, it should do that internally before it publishes its decision. It shouldn't publish a kind of, a temporary decision and then go and try and figure out what's wrong with it. That's bad administration. And it opens it up to saying, well, did you actually decide it, or are you just changing the words to get rid of the judicial review? And it kind of relegates the decision to a kind of a formula of words to avoid judicial review, whereas kind of case law and general legal principles are that the written decision has to record what was decided and the reasons for it. So if that's kind of now a fluid concept that can be adjusted when they spot a mistake or when somebody challenges it, it kind of completely undermines the kind of administrative system that we have, and it'll give rise to an awful lot of litigation.
Okay, which is something that we want to avoid. That's one of the
absolutely.
principles. I'm sorry I ran over time.